Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a business valuation expert in St. Louis, Missouri. During this episode, we will discuss litigation and arbitration or post-acquisition disputes from a CPA and an accounting expert. We have the privilege today to discuss these issues with Scott Stringer, a fellow testifying expert and arbitrator in Naples, Florida. Welcome, Scott. How are you?
Hi, Melissa. Thank you very much for having me.
Yeah, this is a great topic, I think, pertaining to litigation issues. But one of the first things that we should start off on is, can you help us understand this topic a little bit more? What is post-acquisition litigation?
So post-acquisition litigation is where a company has been sold to a buyer, and the seller and the buyer both have different ideas about what they sold and what they bought. And as a result, those disputes are either resolved by language that's put in those agreements, or those misunderstandings or those disputes come to a trier of fact, which would be an arbitrator or to a court, depending upon how the purchase agreement is written.
So, what has been some of your experience in this area, or in general litigation support services?
So I do a variety of different types of litigation and damages in litigation. But post-acquisition disputes is one of the segments that I've done an awful lot of work in. I have been an expert witness for both sellers and buyers who have had those disputes, who have gone. Some of them have settled. Many of them, I'd say most of them, have settled prior to going to an arbitration panel or going to trial. I've also, because of that experience, and again, we're going back, probably first one was probably 30 years ago, and probably 15 years ago or so, I was asked by a judge to determine what working capital was supposed to be on a very small business, because he did not want to take that into his courtroom. He said that belongs in the CPA world. So I acted as a neutral. I reported to the court and basically got the information. Subsequently did that when I was in Chicago, my second go around, and did that. And again, still also doing expert witness testimony. And then several years ago, I was actually hired as a private arbitrator on a large matter where, again, they had about 10 or 12 things they didn't agree on. And they were very much they're very much determining, is the seller right, is the buyer right, and we had different answers depending upon the different issues.
Well, and some of the things that you have been doing having to do with litigation support and being a testifying expert is around these acquisitions. And so you have somebody that sold the company, and then you have a dispute in some nature. It's usually not the purchase price, but it's other adjustments, basically.
Right, and I'd say one bucket of disputes that I've done a lot of work in, particularly as an arbitrator, would be working capital disputes, and it's working capital disputes, and it's also earnout disputes, and I think those are definitely two different things. Earnout disputes are a little more tangible, I think, to understand. Many times a seller will agree, if they sell a business for, let's just make them $10 million, they're not going to generally receive $10 million worth of cash. They're going to get some amount of cash, they're going to get some amount of deferred payment, and they're also usually going to get some kind of a what that we call an earnout agreement. Okay, the seller or the buyer goes, you think it's going to make $3 million a year? Boom, let's stake some of your compensation on it. So they have a piece of they have some skin in the game. There's a formula put together in those agreements, and they all do their numbers, and they figure out, well, gosh, if it's doing what we think it's going to do, I'll get the rest of my purchase price. approximately X or Y, et cetera, and I'll be able to earn that after the sale as a consultant or as through an employment agreement. The problem is that those tend to be disputes that happen a lot, and they happen a lot because there's something changes with the business, something can change with the economy. Boy, we know that now, don't we?
Yeah.
Something can change with the way the business is run. Something can change by the way the new buyers run the business. And so the seller sometimes will take umbrage to that and say, gosh, if I was only there, it would have made X. You guys messed up my company, et cetera, et cetera. My earnout should have been X, but you guys messed it up, and so I'm suing you. They either do it that because of that, or there'll also be issues as to how generally accepted accounting principles are utilized, right? So, they're saying, what you're doing, you're not recognizing revenue enough. You're doing some things purposely to lower my earnout. And so we see disputes all the time. I've been, as an expert, I have not been an arbitrator on earnouts, but I have been an expert witness on those. And in my mind, it's the most contentious part of an asset purchase agreement or stock purchase agreement, because things can change awfully quickly.
Mm-hmm. Well, and one of the things, so you've talked about two types of disputes. One is the working capital and one is the earnouts. So I want to know if there's other types of disputes, but when you encounter these, do they typically start in arbitration and then go to litigation, or the reverse?
And I apologize. So I use the term litigation as any dispute, right?
Okay.
So going to arbitration is an alternative dispute resolution, but in my mind, it is a dispute that's being resolved by a neutral. So it's really litigation in my mind. But they go to either to arbitration or litigation, and typically, if they go to arbitration, it's because the parties have agreed in advance in the agreement to go to arbitration. We see those in employment clauses. We see them in lots of other things as well. But I think your question was, what other types of disputes were there in litigation? Okay.
Sure. Yeah.
So you had the earnouts, and I did that because it's more it's a little easier to understand, and it's just so of all the disputes we have, it's one that I just think that a tremendous high percentage of them are disputed because it's just how soft that can be, and the seller loses the entire control of their revenue stream. They handing it to the buyer, and the buyer, if the buyer has a bad year, the seller is immediately going to say, you're manipulating my numbers. If the seller has a good year, of course, the buyer's not going to say anything. But so I started with that. The second one, really, where there's a lot of nitty gritty and where I have served as an arbitrator, and that's going to be working capital adjustments. So when you buy a company, most people are buying a company because of what they think it's going to earn in income, right? So it has, it's not so much about the balance sheet per se. It's really, is this a good company? Is this a strategic fit? If I'm a financial buyer, what's my earnings going to be as a percentage of revenue? Is my profit margins great? Is the industry good, et cetera? And but the balance sheet comes along with that, and on the balance sheet can be accounts receivable, again, which is a promise to pay, accounts payable, these are my debts, cash, and so on and so forth, inventory for manufacturing companies. So these are not insignificant components to a purchase price. The difference, what makes these contentious is that you cannot predict those, what those are going to be on the day to close 3 months in advance, because those are the kind of things that change with every transaction, every day. And so companies will determine what a target working capital number, and that target working capital number is agreed as part of the purchase price. And then everybody works to get this thing closed. The thing finally closes. there is a post-closing balance sheet that is done, and that post-closing balance sheet should be the exact minute that the transaction happens. So, that's what the buyer bought was this point in time, 12 midnight on X date. Take a snapshot of that. Oh, I did that. There you go. I did. Okay. And so then each party, so then the buyer would then and the seller would come to some agreement as to the working capital number and compare and contrast that to the target. And in a perfect world where everybody plays really well with each other, and everybody's on the up and up, and they've got a great relationship, and they go, oh yeah, this is that and this is that. It doesn't even get to arbitration. They settle it among themselves. And but in many cases, sometimes it isn't the whole thing, but maybe there's 2 or 3 items. Maybe there's 6 or 7 items that they can't agree on. And typically the asset purchase agreement, which is versus a stock purchase agreement, will spell out, what do we do if we have working capital issues? And so in many cases lately, and I say lately by the last 20 years or so that I've been involved, they typically have arbitration clauses that either allows for some independent neutral who's not identified, or what I've seen in the last decade or so is that they will, because of the financial nature of that, they will stipulate an accounting firm or an accounting, a range of accounting firms, or national firms or whatever, that each one would agree to. And so that is how I've served as an arbitrator in post-acquisition disputes.
Well, and you kind of bring up a really good point, about post-closing adjustments, because this is the crux of the dispute. But and what I have seen and what we've talked to clients that are going through this process is that, at the date that you get an LOI, they say, you provided a balance sheet. So they say here, they know what your working capital was as of that date. It could be 3 to 6 months until you close. During the meantime, I'm kind of advising that they start collecting their receivables, paying off their payables. So working capital is going to go down. But then you have, talk to us about these post-closing adjustments, which are really what people are arguing about. Are these just accounting adjustments, GAAP adjustments, or working capital adjustments, or all of it?
So when I say adjustment, they're adjustments to the purchase price.
Right.
Right. So they're really not adjustments to the books per se. They're really adjustments to the purchase price. So the purchase price is predicated on having $9 million in working capital, and it appears that there's only 7. Okay, so you have an adjustment of the purchase price, and let's say they agree on the 7. So now the purchase price is adjusted by $2 million. Okay, right. But then you have disputes as to what those adjustments are, and that's where I get involved.
So talk to us, give us an example of one of the disputes of where they didn't agree to the adjustments.
Okay. So a real common one is where accounts receivable, accounts receivable are typically stated as, that's a subledger, and it has everybody's account in it, and account balance and invoices and such, and that's going to be exactly what you invoiced them. But then there's what they call a contra account that is maintained, because in a perfect world, everybody would pay their bills. In the real world, not everybody pays their bills.
Right.
Allowance for doubtful accounts, it's called, and that is a subjective determination by a company as to what percentage of, or what percentage or what amount of the existing accounts receivables they believe is collectible. There's lots of formulas. There's lots of right ways to do it, and the matter is being consistent in doing it. Companies will look at their historical performance. They'll look at their specific customer makeup. Do we have risky customers? Sometimes they'll do it on a macro basis. Everything 90 days and over is going to be we're going to fully reserve for that. They use the word reserve. or we're going to do 50% of whatever. Sometimes they'll do it on a macro basis. In post-acquisition disputes, they tend to bear down. They should bear down a little bit more and maybe look at specific customer accounts, particularly if they don't have thousands of customers, right? If they have a smaller sample set where 3 customers make up, 40% or 50% of their accounts receivable, they probably should be looking at those customers and their businesses and their history and so on and so forth. So the seller will make a representation to that because, again, even though the buyer can come in and kick the tires and look at the books and do all those other things, until they give the keys of the car to the buyer, right? The seller is in charge of that thing. So so the seller, a lot of times a dispute will be, the buyer will say, you know what, these receivables stink. You had a 30% reserve. We have followed up with these customers. We've done our own internal due diligence now that we're driving a car. And we believe that the allowance is $1 million understated. And therefore, we are proposing $1 million decrease in the purchase price. And so that is a very, very, very typical type of dispute that would come before a CPA arbitrator.
Okay.
Yeah. And then there's the other ones. A lot of them are, and again, that is an example of generally accepted accounting principles, but it's a subjective analysis, right? There's other issues about deferred revenue, where you, in essence, you've been paid, and you've already been paid for something you're going to have to perform later. A lot of times those are in license agreements, et cetera. The buyer wants more of that recognized in advance because the buyer basically doesn't want to have to recognize income on money that's already been paid.
Right.
So there are many ways to do this correctly, and a lot of complex. When I get hired, it's usually not very clear, right? So if it was really clear, they wouldn't need me. So the one I did, for example, was 2 international companies who had multiple master license holders who then had sub license holders and territory holders. And when licenses got recognized was a matter of art and application of not only generally accepted accounting principles, but IFRS, and had been done that way for a number of years. In different countries, they did it different ways and so on and so forth. But in essence, they came up with a way that did it that was really in compliance with what we consider to be GAAP. The buyer disagreed with the way that GAAP was performed, right? The buyer disagreed with that. And as a result, and I was actually the arbitrator on this, threw tons of GAAP and IFRS issues at me that were true, but so was the other side, because under GAAP and IFRS, when these issues came up, you could do it either way. It really depended on some subjective decision making about when did the users use it, et cetera. The point to this is that what Wade, once I took the evidence and looked at it at both hands, you go back to the stock purchase agreement and asset purchase agreement, which says GAAP as consistently applied. So you can go through all of this analysis, and that you still have to, if one side has represented, I've done GAAP, but it's not GAAP, then that's one thing. Then you would have to say, well, we don't care how you've done it in the past. You didn't do it according to GAAP. So I had to go in and basically say, while maybe your GAAP seems good, and maybe it even is better than their GAAP, they're still GAAP, and you agreed in the stock purchase agreement, in the asset purchase agreement, whatever it was, you agreed how GAAP was consistently applied, you agreed to those terms. So the burden there is to prove that something was not done in accordance with GAAP when it was represented that it was done in accordance with GAAP. And so these are the really interesting parts of my job, is to be able to look at those. And yeah, when we get those kind of things, I have to bring experts on my team who know lots about GAAP and in specific areas, in specific industries too.
Well, and I think prior to this call, you kind of mentioned damages due to alleged misrepresentation of financial information and non-disclosure of material items. Right. What are some of the, because this is a little different, like you have the adjustments, but now this is an example that there could be damages, but what are we looking at in this type of, when somebody is misrepresenting their full financial picture? Is this just a completely different type of damage?
Yeah, and I would say post-closing adjustments are not usually damages. They're basically, I bought a company that I thought had, I like my car analogy. I bought a car that I thought had a V8 and it had power windows and it had hyper great brakes and all these little latches. Then when I got it, I realized those things weren't there, or they were broken. And so we make those adjustments, and you say, well, no, that wasn't broken. That wasn't my fault. That was your fault. So that's what post-closing adjustments are. The second part is really a lot different, and that is you told us this was a $100 million company. You told us you owned these patents. I've had those before. You've told us that you anticipate opening new plants to expand, that you've got these plant constructions going on, and that the opening dates are going to be X, Y, and Z. And you found out prior to the closing. You found out months prior to the closing that none of those were going to hold water, but you didn't tell us. Had you told us, instead of paying X for it, we would have paid Y for it. So we've overpaid. The buyer will assert we've overpaid because you knew information that impacted the business and didn't tell us. Number one. Number two, and I've had this before. These are really interesting. You committed a fraud on the buyers, right, for your own benefit, and that's an assertion. It's a civil fraud. I'm not an attorney, but that's usually what the term is utilized. And you've done it maliciously, and we are damaged. But for your actions, we are damaged. And then there has to be determination and a calculation to a reasonable degree of professional certainty, using the evidence and causation and understanding and of what that damage is. And it gets murky because a company can, I mentioned to you, we thought we had a $100 million company. It's only doing $60 million. Establishing that causal link is the key to being able to just say, yeah, the reason we didn't do 100 million was because of your misrepresentation. Because you have to weed out whether it was because the general economy, because a specific customer went under that you didn't, there was no way you anticipated that your supply chain was messed up, that COVID-19 hit, that there was state, that the government shut down your businesses. You can't associate, you have to separate all that out. And it takes a really complex analysis to be able to find the causal link and segregate out all of those other. So you basically, as I've said before, it's like on the forensic files or whatever. Expert, you have to rule out all the other suspects. So before I can, I think you're the suspect, but I can't take you to trial unless I've eliminated all the other suspects. You have to eliminate all the other causal factors. And that is the hardest part, I think, to do. It is, you definitely can do it. I've been an expert for both plaintiffs and defendants in these cases. It takes a lot of work to be able to do it, but you can do it. But it takes a lot of looking at the evidence and then again, understanding that causal link and it's just not a matter of doing the math.
Right. I mean, a lot of this is subjective, either with the, we call them post-closing adjustments, but it's basically the purchase price adjustment that you've described. And then the other is, what did the seller know or didn't know? I mean, these
Mhm.
are some cloudy areas
Right.
that really take a ton of analysis. But with the experience that you have, what could an attorney or business owner do differently in the closing agreements or in the closing process to prevent litigation? Because we have to remember that when somebody goes to sell their company,
Mhm.
this could be the first time that they've done this.
Mhm.
This could be the first time that a buyer has bought a company,
Mhm.
and they don't know anything different. And sometimes maybe they will try to cut costs or get, some agreements together that maybe are not as robust. But even then, it's hard to keep
Mhm.
them on. So, do you have any concepts that maybe they should include in the closing agreements to help prevent some of these issues?
Yeah, I think so because it's a lot of times it's funny because we'll go through these litigation. We'll go, wow, if that only been written a certain way. So I had an earnout provision one time. This had to do with uh, a seller was going to, and this is pretty typical. I'm just thinking of a specific one right now. A seller was supposed to make stair step percentage commission if the net income of the company got to certain levels. So at one level, he got 5%. When he hit that second level, he got 20%, 10% or whatever. And the company didn't do what it was supposed to do, I guess, or didn't do the amount of income they thought it was going to do. And the big issue was the interpretation of what net income was.
Mm-hmm.
So you have to really, I would say to attorneys, when you're doing a closing agreement, have an individual, a CPA, or maybe a CPA who's also a lawyer on your team, who's got significant amount of background in this, to really talk the gap, right? That it will be earnings before interest, taxes, depreciation, and adjustment on a generally accepted accounting principle basis, utilizing the accrual basis of accounting as typically applied. The more specific you can be in the agreement as to what the earnout is based on, that will help litigation. Almost every earnout situation I've seen, with the exception of fraud, has been a result of just not clarifying the terms.
Yeah, and making gross assumptions, because I've also dealt with some clients that have, talked about earnouts based on revenue, because sometimes getting to that net income or EBITDA or anything from a cash flow perspective, you have adjustments.
Right.
And those are where you're going to start arguing. Whereas if you say we were at 5 million, and if we get to 7 million, I get an earnout. Then I think that they've been a little bit, the attorneys and business owners tap us all the time to review buy-sell agreements, but not so much on the closing agreements. And these are complex issues.
Right.
Another thing, I've seen them be inconsistent with fair market value and fair value, or discussing discounts. If there's an issue that comes up, and I think that those are, when you buy out a partner or buy in a partner and things like that, sometimes those are things that can catch somebody up.
Right.
What other things happen in those closing agreements? So also you talked a little bit about arbitration clauses. A lot of these companies have arbitration clauses, but maybe to specify who to use or what type of arbitrator expert to use.
I mean,
Has that ever been
a lot of
helpful?
them will say, I mean, there are people, a lot of them will say AAA or JAMS, American Arbitration Association, JAMS, and those are not necessarily the most, again, arguably, they can be more expensive than a sole arbitration by a CPA, because the CPA is going to probably be, they're bound by typically they should be, bound by the AAA arbitration rules and so on and so forth. They're going to have specific knowledge of GAAP, and it's just a much more efficient process. And if the buyer and the seller can both agree to it, it makes a ton of sense. The other thing, and you had mentioned this earlier, and I would just say, disclose. If you're a seller, disclose.
Mm-hmm.
Because, get the laundry out now, because if your buyer's going to find it, and then it's so much easier to just get it out there and deal with it. No business is perfect, and it just, you'll end up in the long run with a lot more headaches if you don't disclose, even if it's the week before. It's just like, oh my God, we agreed on this. Well, maybe it'll be okay. My customer, who I thought was great, I just found out they filed for Chapter 7 bankruptcy, or not Chapter 7, Chapter 11 bankruptcy, and we're going to be on a creditors committee. You know what? It's a week before close. I'm not messing with the allowance. No. You
right.
call your attorney, and you get that out in the open.
Right.
And then everybody plays better, right? Because it's like, look at the credibility you have as a seller when you've done that right before closing. It just makes it a much smoother process.
Well, and there's so much trust issues when you're going through some sort of merger, acquisition, deal in any respect. One single thing that could make me question whether you're fully disclosing things or pertinent business information could really even ruin a deal.
Mm-hmm.
But a lot of times when we talk to sellers, we're saying, anything in an earnout or any of these things in a working capital situation are going to have to be negotiated, discussed, and renegotiated post-closing, because, so be happy with what you get at the closing table, but because some of it, the buyer is going to try to argue against the earnout. And if there's a way to do it rationally throughout the agreements, they might try to do that. That's normal.
You talk about bad feelings in a closing. One of the very first ones I did about 25 years ago or so, and I'm going to try to be careful here, but the asset purchase agreement was written in a very general way and was not specific about the workforce in place. The workforce in place, and there was, and I think by the letter of the agreements, that the seller was probably in compliance, but not with the spirit. So the buyer goes to takes possession, start running the business, and the entire workforce goes to work for somebody else. And it turns out that they were able to trace that to, we're not going to be here anymore. You can do what you want to do, so on and so forth. And the issue was they knew they were going to lose the workforce, but the asset purchase agreement wasn't strong enough to kind of address those issues, and that went to litigation. That was yeah. But talk about, and so when something like that pops up, and of course what happened was I was working for the buyer at that time as an expert witness. Now everything's on the table. They lied to us about that. What else are they going to lie to us about? So everything got picked apart, and it was a disaster. And of course, lots of legal fees, lots of expert fees. Well, it's settled before trial.
And a lot of times, I think what sellers don't always understand is that there will be some amount of the purchase price held back in escrow based on the reps and warranties that you have provided at closing. Right. So it's not, but there's probably also sometimes that they may have to pay some back, and so that's where I think people start to get really interesting, is if there's money just sitting in an account and they have to fight about it, they know it's there, and they don't want to give it, or somebody doesn't want to take it. But that's where I think a lot of things are happening now, kind of having to do with what's happening in our current economy. How do you believe this economic landscape will actually impact different types of disputes or damage assessments? I have my opinion, but let's let you go first.
Well, yeah, I don't have my Karnak hat on here, but
right.
I'm just based on my experience of going through downturns before. What I think we're going to see is, the economy was doing great through the end of 2019. And so earnings projections were great. I would say compared to like 2008, 2009, we don't see earning multiples the same, but still it was a decent earnings multiple, but a nice projection base, 4% a year, 5% a year, 6%, whatever. We're going to see those sorts of things. So you have deals that have closed prior to 2020, and that's all I have to say. Prior to 2020, those sellers are hurting. I'm sorry, those buyers are hurting. They now bought a Ferrari and they got a Pinto. Okay,
right.
And so they are, in order to get some kind of, they're gonna start looking under the hood really closely. And if there's anything that sniffs like it was fraud or misrepresentation or whatever, litigation's going to commence, right? Whether it's an arbitration, if they've passed, a lot of times on those post-closing adjustments and such, there's a limited amount of time to respond. But if you assert that there was fraud, you can again, I'm not an attorney, but that might be asserted months after the agreement might specify. So I think we're going to see buyers and sellers arguing about the purchase price that they paid for a company. I think that earnout provisions are going to be people are going to sue for earnout provisions, particularly if they were based upon something that's not necessarily earnings. They based it on revenues, or if they just did a flat amount. Sometimes the earnings are, you know what, we're just going to keep it simple. We're going to pay you $5,000 a quarter. Right. So now the buyer is going to say that was based upon X. We need to renegotiate. Kind of like the Major League Baseball Players Association. They're not going to make $20 million now because they're not playing 162 games. So there's going to be those kind of things that come to dispute. I imagine a lot of those will settle, but human nature being what it is, it's probably not. And so I expect to see some of that in arbitration litigation as well. And I would also say that there will be difficulty. I guess there will be difficulty with misrepresentation. To be able to prove that somebody knew that COVID was going to happen, knew that there was going to be state sanctions. So any kind of, and there could be very legitimate claims for those things. But any expert witness now, any plaintiff is going to have to be able to separate out the effect of COVID and all these other things, even if there was fraud and misrepresentation. So if I was an expert witness and I was hired by the buyer to determine what that overpayment appears to be based upon the economics of the deal, I got a lot of work ahead of me. All right. So, but there's databases, there's economic analysis you can perform. There's historicals, there's industries. It's just going to take a ton of work, but the burden of proof is on the plaintiff to determine to a reasonable degree of professional certainty, as an expert, professional certainty, that there was a causal link. And so you have this convolution of bad deals are happening, and then a bad environment is happening. And so that's going to make the disputes even more complex. So I think we're going to see a lot of litigation, and it probably will take a little while to get through the pipe, just because of so much is going on with our courts right now. So
yeah, I mean, we've already been kind of put behind a few months with court dockets, but another area that I think that we're going to see some issues is that a lot of times the earnouts are predicated on the owner staying for a certain period of time. Right. And so when this happens, first of all, the owners are already on the retirement path, right? Yeah. So they don't want to work a lot. I mean, they love what they do, but they've handed over the reins. They're ready to scale back. And now you have everything thrown into craziness. And I don't think you're going to see sellers want to escalate their involvement in the company. I don't think they're going to want to pivot and come up with new ways of doing this. They might just want to leave and be done. And they might not be positioned to really have a emotional investment in the success or the future changes. And so they could exit, which then triggers, okay, now are you going to pay the earnouts? Are they not going to be paid? You know, I think that there's going to be a lot going on. Are they really putting effort forth? You know, we're in a new environment where business needs to be done different. So
that's a great point too. And I would add to that, I just thought of another one, is consequential damages to a seller who decides, you know what? I thought I was going to be here 3 years. I didn't know I was going to be in this post-COVID world. I'm done. I'm done. You don't have to pay me, but I'm done. Well, the buyer's going to go, you are key. You're a key person.
Right.
I bought this under the understanding you were going to be here for 2 or 3 years while I learned the business. So there could be an example of a buyer selling, litigating against the seller for the damage, consequential damages of them leaving and breaching their contract. No, I want to pay you. Yeah. And they go, I don't want to.
Right. Absolutely. They'll be like, I don't need my salary. But you also have a situation that as a consumer, if I look as a consumer, if I were a vendor, a client, and we're already in such chaos, right? I maybe am reevaluating. Do I need this particular, should I work with this particular company? And now the owner all of a sudden leaves. And I'm like, well, I'm trying to figure out new options anyway. And now you start to lose clients. And that's where I think that you're going to have litigation coming back and saying, you know what, we did overpay.
Exactly.
But was it due to COVID? Was it due to owner leaving? What, you know, that's where the expert is going to have a harder time, where you talked about it. You have to segment and identify the causation. And if it's all of these other extraneous issues, what is really the fault of the seller or the buyer?
Exactly.
And can you prove it? You know?
Exactly.
But I think that's the harder part.
Yeah, and and that's a slippery slope too. It's because it's subjective. Because each expert witness, it's incumbent upon them to determine what the level of evidence is, and you can never do anything to 100% degree of certainty. I mean, if you could, nothing would go to litigation.
Right.
But to a reasonable degree of professional certainty, and it's astounding how many expert witnesses will have a different interpretation of what that is.
All right. Everybody has a different opinion, you know, and can you support it, especially in a time that we're all sort of living through this time for the first time. Yeah. And I think that's the harder part, is that there is no reference point. You know, we've gone through other crises, but there's no reference point of how to get out. You know, housing crisis. Okay. Did it affect everything? No. I mean, a pandemic, it kind of affected the entire world. So that, I think, is some issues. But just to kind of talk about one thing that I think is important is that we talk a lot about litigation, and you and I both love to testify and love to be expert witnesses. It's just kind of a passion that we both have. But I see things moving towards mediation and arbitration. And you we were talking about this right before you came on, you know, that you have been an arbitrator and you are now going to be an arbitrator in other capacities. But tell us more about that role and how it's a little bit different, you know, as we try to mediate, or, you know, it's alternative dispute resolution. We know that, you know, ADR process. But how is it going to be different? And do you see things moving in this direction more?
You know, we call it ADR, alternative dispute resolution, and it generally encompasses mediation and arbitration. Mediation is, if you serve as a mediator, I'm not a mediator. If you serve as a mediator, you help two parties come together, and you say, what are your issues, what are your issues, etc. You try to get them to find some common ground. As an arbitrator, mediation, by the way, what I've seen is that commercial litigation, almost at least at most of the federal cases I think I've been on, and probably a lot of state, mediation has been required by the court. So mediation fails, you go to the next stage. You go to arbitration. At the arbitrator level, think of an arbitration as a jury. You're really, instead of having a jury of lay people, an arbitrator, particularly a CPA arbitrator or whatever specialty that arbitrator is an expert in the matters that are at issue. So you're able to have more confidence. Arbitrators will generally be skilled in the field, et cetera. If an arbitrator is a judge, the issues pertain to the law. That's why a lot of arbitrators are lawyers. I'd say most arbitrators are lawyers. In acquisition disputes, particularly working capital adjustments, it's so dependent upon a knowledge of generally accepted accounting principles, interpretation of those things, understanding the purchase agreement and how that works with GAAP, understanding, looking at a balance sheet, looking at the details to the balance sheet and to the income statement, listening to both sides, and because this subject so much better than the layperson on a jury. So, as an alternative dispute resolution tool, it helps you get to the right answer. Juries, I've been in front of a lot of juries. Juries don't always make the correct call because they're swayed by the powers of persuasion of the attorneys and the veracity of the evidence and good experts versus bad experts. With arbitration, particularly in acquisitions with a CPA or a financial professional who's well skilled at this, it's going to be very much more fact-based, and I think a much more fair determination of the outcome of the case.
No, and I completely agree. I mean, I think you've seen it, we've seen it in litigation where either they're requiring some other alternative first before they can go into the court system. But we're also seeing it as like special masters or getting experts together and talking through that. It's, and a lot of people want to say, well, this is so complex that people don't understand it. The real thing is it's such a depth of knowledge that you have to have about these things that it just is very easy for us. Yes. And not everybody can understand it. So when you're talking about a working capital adjustment, I think having an arbitrator that understands that concept so deep can actually make the right decision and help the parties come to an agreement and closure than necessarily just an outside party that understands law. Because that's a very there's a legal premise to it, but there's also the financial proving of the situation. And so that's where I like to see that, they're having more financial experts, CPAs, in the role of an arbitrator, because the courts don't actually want to take it into either a bench trial or a jury trial. It's just too much. They get two experts that have similar pedigrees, and they're like, well, you both make sense. So who's right and who's wrong? Right. Whereas you can kind of come in and say, it's maybe there's not a right and wrong, but there is a righter way of doing it and a better way of looking at this that I don't think anybody could come up with unless you have done this type of calculation many, many times.
Correct. I agree. Yeah.
So one last question that we have is that I have known you when you were in St. Louis, and then you moved to Chicago, and then now you're in Florida. So you have a new firm. So maybe you can tell us more about your firm, what you're specializing in. Sure. You don't just do this, you do a lot of other things. So tell us some more.
Yeah, I don't just play golf because I'm in Florida. So I am a former partner at a national accounting firm, and I left that world about 7-8 months ago basically to focus on my clients only, and not so much about working in a big environment. So I wanted the ability to be able to really pick and choose who I worked with, and really put the client's interests first. And that being said, then the question is like, how do we get work done? So over the years, I've been partners in several firms, several national firms, and then smaller local firms over the years, as well as consulting firms, and have a bunch of people who have done the same thing I've done, which is later in their career, they've started their own company or whatever, and we have historically, in an official and unofficial capacity over the last 5 years, helped each other out on cases. What do you think about that? What do you think about this? And so I have an alliance of about 6 people, from the partner down to manager level, who now work with me as needed. And we just did a huge federal case in Florida here that's pending, and it's possibly growing to something bigger, and we've got other big opportunities. So because of my experience in working with teams over the years, I basically bring those teams together when it's ready. So my firm is really me, who then looks at cases, gets the right resources. A lot of times the right resources aren't here. So the last 3 referrals I've gotten have been for people that are more qualified to do that particular job, because I think it's important to stay in your lane. And I think of myself as a problem solver who tries to help, lawyers and companies figure out what's the best resource for them. And that's fulfilling to do that, and I enjoy that.
And your background has really always been in being a testifying expert in various commercial litigation, as well as you've done a lot of forensic accounting, fraud investigations and things like that. So it's probably nice now to be able to choose a few cases that you spend quality time on, and try to enjoy a little retirement. Little bit of golf, a little bit of beaches.
Yeah, I get a little bit of that in between 15-hour days working on a case. But that's fun. I really enjoy what I do. And then you're right. I've been doing this a long time, but I'm classically trained as a Big 4 auditor. Back when it was Big 8. So my background is coming up through that world, and it's funny because that old audit training really helps me to be skeptical in nature. As an expert witness, my first comment is, what's my cross-examination? Why is this going to litigation? You're saying X. I'm going to be your sounding board. Why is it that way? And I want to I want to see all the warts, etc., because auditors are supposed to be skeptical, and I have that audit skepticism. So, but then I've been lucky enough to get involved in forensic accounting in its early days, 30 plus years ago. And it's a blast. And I've been doing it full time. I was a partner in audit firms. I was full time doing this now for about 20 years, just doing forensic accounting. So, and I still love it. I'm going to hang on till I'm way, 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 way up there. So I'll always be semi-retired.
Well, I think that's great. I think this has been very helpful for people to understand. And maybe there just has to be a little bit more planning at the beginning, when you're doing the closing documents. But the reality is, some of the stuff you can't avoid. You're going to have difference of opinions in how somebody views the same thing, and it's always going to continue to happen. So I really appreciate your time and information, and maybe we'll have you on for another topic in a couple months.
Thank you very Scott. Much. It was my pleasure to be on, and I appreciate the opportunity to speak. Thanks,
awesome.
Melissa.
Thank you.
Mm-hmm.